in regard to all firms doing court report business in the legal field, court reporting field. I'm using air quotes around that court reporting field, the court reporting business in this state. And if you don't know, I'm an official court reporter in San Diego. I've been with the San Diego court for 30 years. Um, and by the way, Carolyn, I reviewed this language this morning because I believe the bill was on, there was a hearing on it yesterday, so I wanted to be sure that I was aware of any new amendments to the language. And I am aware that it is May language, and those the parties that are lobbying on behalf of the official reporters in the state have done a fine, and I'm a member of SEIU, so the unions have done a fine job, and the representation of official reporters has done a fine job of advocating on behalf of official reporters, and the language has expanded dramatically from the beginning of from the introduction of this bill and the remote language. So I know that's not brief. I said I was going to be brief, but considering that the board has a fiduciary duty to and consumer protection is our what we have to look for, and our shining, that's our guidance. That's what our job is consumer protection. I just think in weighing the two, we have to support this bill. So having said that, do we need a motion, or we're currently in support of this bill? Is there any further comment? And I am going to ask, rather than move on, is there anything further that we need to do on this, on legislation on this agenda item?
No, if you are happy with the position that you are in, then there's no further need for action.
Okay. And I do want to address one more thing that I wrote down. I believe, Ms. Dasher, in your comments, that you had made the suggestion that there be a committee set up to take a position on further legislation. I would ask that you please put your request in writing, so we send it to board staff so we can address that issue, and we know exactly what it is that you're requesting. And with that, we will move on to agenda item number 7. Ms. Fenner, would you update us on where we are with AB2138 regulations?
I am actually going to punt that one over to Ms. Rogers, our legislative counsel.
Good morning, everyone. This is Danielle Rogers, Regulations Counsel for the board. Regarding AB 2138, the Office of Administrative Law approved the AB 2138 package to be effective on May 12, 2021. Regarding item 7.2, I will let the executive officer explain where we are on that item, and I will take back control on 7.2.
Thank you very much.
So moving on to 7.2, at the end of the day, and there were lots of days and discussions, the regulatory pathway appears not to be supported by our existing statutes. So in the meantime, I think that the board can take some steps to make sure that we educate the attorneys on the importance of using a certified shorthand reporter. So the board can continue outreach through the various bar associations throughout the state. We have developed the piece on the reasons to use a licensed court reporter. We can continue to disseminate that, but something that the court reporters can also do right away without delay is stating their CSR number at the beginning of every proceeding, much like the interpreters do right now at the beginning of any proceeding. I think it's important that we focus on those because they can be implemented right away. Are there any questions from the board?
I would open it up, since I'm seeing none, I see no hands and I'm hearing none. I would open it up to comments from the public.
Thank you, Madam Chair. I've opened up the Q&A panel. If any member of the public would like to make a comment, please type. I would like to make a comment using the field in the lower right-hand corner of your screen. It's submitted to all panelists, or you may raise your hand. We'll give you a moment. This is the moderator. I see no request for public comment at this time. Would you like me to close the Q&A panel?
Yes, please.
Okay, it's closed.
So I would ask staff to continue to educate the attorneys on the importance of using a licensed CSR. And I too reiterate what Ms. Fenner said about encouraging reporters to identify themselves as with their CSR number at the start of proceedings, and also educate the attorneys that you work with. And this was, and I believe it was Miss O'Neill that brought this up. This was what they did, I think you said back in the 80s, when an issue arose, they encouraged the attorneys to ask for the reporter's CSR number at the start of proceedings.
Yes.
To ensure that they had a licensed CSR as their
Yeah.
reporter. So
That's the time when, in the 80s, before the particular legislation went into effect, the attorneys could stipulate to a non-CSR. And then we got legislation that said, no, they had to be licensed. And so, and I can still remember how surprised I was that of the number of attorneys that was asking me to see my license. So somehow, I don't remember now how we got the word out, but on Ms. Fenner's recommendation to educate, sort of like on the job education, I like that approach because, as she said, it's much quicker to get out there. And and this is sort of a anecdotal, information, but I on my, how when you're in Zoom, you can type your name in. Well, what I started doing, I changed it and I have my name typed in all caps. Plus I have CSR number sign in my CSR number. Nobody said anything. I didn't think anything of it. And then I ended up using Zoom for my siblings things and stuff, and some other things. And so I took off the CSR number, 5482. And when I took my next Zoom demo, I forgot to put it back on. And one of the attorneys actually asked me what my license number was. And I just think we need to hit them over the head constantly that, I am a CSR license number, or come up with some language, just as Ms. Fenner said, similar to what the interpreters do. I think that will actually be more effective and more timely to arouse, to raise awareness than waiting for legislation to go through. That's all.
thank you, Miss O'Neill. And then we will move on to agenda item number 7.3. Our last regulation related to minimum transcript format standards. Ms. Fenner, will you give us background, please, on this item?
Actually, I'm going to tag Ms. Rogers with that one as well.
Thank you.
Thank you, Ms. Benner. So this is item 7.3 that is on the agenda. This is pertaining to the minimum transcript format standards regulation, which is in regulation at section 2473. You're proposing an amendment to that regulation that is set forth at subdivision A12 and is underlined. And that text amendment will provide that text must be in a full text searchable PDF or other searchable format. So at this point, we would have a motion to approve the proposed text if board members don't have any other comments or questions.
Thank you. And before I open this up for discussion, I am going to take the opportunity as chair. So and throw in here that I'm wondering if the standards of I'm wondering, and I would like input, whether the minimum standard should be higher than just a searchable electronic transcript. And specifically, I am aware that official reporters have the rules of court. I'm sorry, it affects more than just official reporters, but any reporter that files a transcript with the court, the regulations, California Rules of Court 8.144D, which was adopted in January of 2018, in addition to being a searchable electronic transcript, it requires bookmarks, it requires digital signatures, it requires that the PDF page counter match the page numbers in the transcript, and there's probably a couple other things that I am not thinking about at the moment, but although it was adopted in January of 2018, reporters have a drop if they do not have to comply with it if they have if there are some reasons they're not able to comply technologically, so they've got a grace period basically until January of 2023, but that is the drop dead date. So those things will be required. I know that reporter software, at least the two biggies, Eclipse and Case Catalyst, the technology exists with those softwares to provide bookmarks. And for those of you that aren't aware, bookmarks, when you open an electronic transcript in PDF, and on the left-hand side, it'll list like basically the index, it'll list the bookmarks. So if you highlight a bookmark, say for the identification of an exhibit, it's a link, it's a hyperlink that'll take you directly into the transcript where that exhibit has been identified or received or whatever is listed in the bookmark, examination, direct examination, cross-examination, etc. So we know the technology is available. We know that court reporters use technology to its fullest as a general rule. But the question is that too onerous as a minimum standard for a transcript? So with that, I'd like to ask, is there a member of before I go to the board, is there a member of the public? Actually, no, I'm sorry. Because I saw your hand up, Tony, I'm going to go to you before I go to the public. So,
Okay.
yeah.
Okay. I have several thoughts about this.
Mhm.
Having been an official for 30 years and now I'm doing depots, you can't, it's comparing apples to oranges. I could see some of those extra features. I could see where agencies could, make some money from, a higher level of service. And this is minimum standards. I'm real hesitant about requiring freelance reporters to do what's in Rule 8.144. And I'm looking at 8.1144.
Specifically, D is the one with the
Yeah,
additional requirements. Just for your,
I was telling Yvonne, I'm so glad I retired from court. I can understand why they're doing it. I'm just glad I don't have to do it. I don't think that as far as the freelance sector is involved, I think what is included like in D and stuff like that it's way above a minimum transcript format.
and by the way, that was 3.5 years ago that it was adopted, but I'm just saying. Ms.
I
Hurt,
know.
oh, I'm sorry.
Yeah.
Were you done?
Yeah, I'm done.
Okay. Ms. Hurt?
Thank you, Chair. I just had a question. So I'm kind of leaning towards what Board Member O'Neill is saying with regards to minimum standard, which is what this regulation is before us. But I'm just curious, as a public member who's not a court reporter, is this as simple as a software update, or would it force people to have to get new machines? Or just curious what your addition means for the average court reporter, and if that software update is pricey.
Robin, in this rural court, does it still have language about if somebody can't technically provide it, then I haven't looked all the way through it, and it seemed like in the bill that preceded this, there was some language about if an official reporter could not provide it, and I can't remember.
There is language, and there is language if a reporter cannot provide it, but they have until January of 23,
Okay.
and they must comply at that point. And to answer your question, Ms. Hurt, I just went through this because I was not doing this, and I, excuse me, was working on a death penalty case. So I can tell you that for my software, it was the update that provides this includes the bookmarks came out about 5 years ago. So as of 5 years ago, maybe longer, Eclipse happens to be my software that I use. It was included with Eclipse. And I did research the other, I'm sure that there might be other softwares, programs out there. I'm not aware of them. The two big ones are Case Catalyst and Eclipse.
Yeah,
I
Case
did
Catalyst does all of this already.
Yes.
So.
Yeah. So it's already there.
Mhm.
So it's
To
possible,
answer-
though, that other software would not include these features that the two big ones you bring forward do.
What I see that the issue is, and the reporters would have to deal with it sooner or later. But you would not believe how many reporters are on very early versions of their software. It works for them. That's, they don't need anything more. They don't want to pay for anything more. And with freelance, it's sort of like the market drives what's being offered. But I also see where agencies could sort of add that as an extra, value, and but they're in private business and they're not in private business to give away.
Okay, I appreciate those comments. Thank you, everyone. I guess it would be appropriate to listen to the public and then make a decision.
And before we do that, because that raises a red flag with me, it is certainly not my intent by by adopting this as a minimum standard to thereby say freelance reporter, you can no longer charge, if you were charging for this as a value added, I can't think of the last, a value added portion of your transcript. So if, in other words, if you're currently charging for the bookmarks, well, now if we require it as a minimum standard or adopt it as a minimum standard, you can't charge for it. I am not that, because so that is not my intent in any way. So if that were to be the intent, if we were to adopt that as a minimum standard, so I have a question. If we adopted this as a minimum standard, would that then mean that it could not be charged for by a freelance reporter as a value added benefit in their transcript?
Well, I would think that if it's in legislation or, well, the rule of court goes to the officials.
But also any freelancer
Oh,
who's
that's true.
taken a civil trial and filing a
Oh,
transcript.
that's true. I wasn't thinking about that. Well, yeah, why would the attorneys pay for it when
They're under the same one.
it's in a rule of court that the reporters have to do it?
Well,
I mean, that's,
I just don't want, if there's an agency owner out there, I guess that's a question. Let me just say that's not my intent. So with that, I would like to open it up
yes.
for public comment, because I truly am interested to hear the perspective.
Thank you, Madam Chair. I've opened up the Q&A panel. If any member of the public would like to make a comment, please type "I would like to make a comment" and submit it to all panelists, or you may raise your hand. I do see we have Charlotte Matthews who would like to speak. So Charlotte, I'll unmute you, and just a reminder that you'll have 3 minutes with a 30-second warning.
Hi, this is
Charlotte?
Charlotte Matthias.
Yep.
Can you hear me?
Yes.
Okay, hi, this is Charlotte Matthias, California Certified Shorthand Reporter number 9792 RPR. This is not a minimum standards issue at all. I really think I agree with Tony on this one. This is a product that is offered after the fact. Our minimum standards is to write every word said at the speed that the board has put. Also to make sure our margins are what they're supposed to be, so that we're not giving margins that are, 2 inches all the way down the page, which was happening years ago, which is why we have minimum transcript format. We're not even required to give them an ASCII or a PDF. We are required to give them a transcript in paper form. And now you're making us jump through hoops to offer a PDF with all these extra things that should not be part of our minimum transcript. This is something that when I worked for a law firm, and I still work for law firms, this is something their paralegals or IT people can deal with. If they want to get a court reporting firm that offers all these extra value options, hot diggity dog. But we are offering a PDF and an ASCII as an add-on. It's not required under the code. I do not believe, unless the ASCII has been added. I don't believe it is. I update myself quite often, but I don't believe it's required. And they can do a word search in ASCII. So why are we making the PDF word searchable? That's an extra add-on that is a feature as a firm can offer to the customer. It's not something this board, I believe, should be involved in. You should be involved in, are we proficient as court reporters and providing a hard copy to the courts and to the attorneys if they wish for a hard copy, and if they don't, we will offer them something else in lieu of, but it's not required. And so I just don't think this needs to be added to our bailiwick, so to speak. We have enough to do as is. Thanks.
Thank you for that feedback. Any other member of the public?
Yes, we have Rosalie Jordan that would like to speak. So Rosalie, let me unmute you. and you should be able to unmute yourself. All right, we will go to another, we'll come back to you because we have Anna Fatima Acosta that would also like to talk. So Anna, you're unmuted. All right, looks like WebEx is perhaps having some technical issues right now because Anna is not showing a microphone at all. So we'll go back to Rosalie. All right, Rosalie, you're unmuted.
Okay, now can you hear me?
Yes.
All right. I'd just like to make a comment that a lot of court reporters are not on Eclipse or Case Catalyst, and therefore I feel it would be onerous for them to have to create bookmarks and use software to create anything more than a searchable PDF. So, and I also agree with Charlotte that law firms in our freelance world are sophisticated enough to do word searches and to find whatever they do. So the bottom line is, I think that if we produce a searchable PDF, that would be perfect. But I feel doing anything more would be difficult for the average freelance court reporter. Thank you.
Thank you.
All right, next we have Carolyn Dasher.
Hi, thank you. What I wanted to say is I agree with the chair that this is something we should look at, this rule of court, and definitely when freelancers work in courts, they should obviously file their transcripts appropriately related to the rules of court. Now, when this law was enacted, or there is a law that's enacted related to this, and I can't remember the code section right now, and I don't remember exactly what it says, but what we were trying to do is raise the minimum requirements and raise the standards and keep court reporters relevant, technologically advanced, because that's what we do, right? For 30 years, I worked in courts for over 30 years before I retired. That's what we were. We were the technology that the court needed with the real time and with being able to electronically file. That's what we were trying to do, keep court reporters relevant. Now, I don't know if you want to add some or a portion. Maybe the board wants to look at the different requirements within 8.144, but if we want to keep the bar high and keep our profession moving along technologically, these were standards that are necessary. Thank you.
All right, we're going to try Anna Fatima Acosta again. All right. Oh, let's try that again. There you go.
Okay,
Anna,
can you
you're
hear me
unmuted.
now?
Yes.
Okay, great, thank you. I needed to refresh my browser and call back in. So I didn't hear Carolyn's entire message, so I apologize if I'm piggybacking or not responding. I agree wholeheartedly with Charlotte Matthias' comments. Court clerks are already, there's so much that court clerks already are responsible for. And I was a litigation secretary supporting a 30-year partner. We and paralegals and lawyers are perfectly capable of creating their own searchable PDFs. And I did that regularly. I'm curious if the person who made this request was somebody an attorney who's angry about the SoCal STIP situation, where court reporters are stating that they will not release the original transcript against the code, that they are following the code, and then they ask for a PDF version of it, and then they can use it just like the transcript, the original transcript. This is above and beyond. I don't understand why we're even spending time talking about this. It's unnecessary. It definitely has nothing to do with the court reporter's job description, or in fact, it can be counterproductive to the court reporter's number one duty, legal and ethical duty, which is to protect the record. And that cannot be done if people who are not qualified, they are entitled to charge for services and their product, the transcripts per the code. So is that something you're willing to state? Who asked for this change? Not the name, but their title or their job.
Ms. Fenner, would you like to make a comment?
I just wanted to answer Ms. Costa's question about how it comes before the board. You may remember from the last meeting that it was from a complainant who was unable to get an electronic version of the transcript. He was provided paper only, and that does not allow anyone to do the search. So this was the genesis of the minimum change.
Okay, so I was not present at that meeting, and I still, as Charlotte mentioned, we are required to provide a paper transcript. I don't believe, is there anything in the code section that states court reporters must provide a PDF version? I mean, I'm all for, technology,
30
and
seconds.
Thank you. It's an integral part of my work, including writing code if needed. But where does it state that a court reporter is required to provide a digital copy of a transcript? And especially searchable.
Thank you, Ms. Fatima Costa. Any other members of the public?
Yes, we have a call-in user, number 11, so let me unmute them or give them permission to unmute themselves. All right, it looks like they're having trouble with the unmute.
Is it *6 like it is on Teams? That if it's a phone user, does *6 unmute, mute and unmute?
Unmute them. That I would have to test.
It's worth a try for the caller.
Yes, thank you, Madam Chair.
I have a brief for *6, by the way.
All right. And they also could maybe type their question as well, or their comment rather. If they're not able to unmute themselves. All right. Well, we have Carolyn Dasher that wants to make an additional comment. So, Carolyn.
Carolyn, I would ask, since you've already spoken once, if you could sum up your comment in a minute, if possible.
Sure, of course.
Thank you.
Okay, because I had to go back, I lost it. But The law that is in effect related to the e-filing, there is a CCP 271 which discusses it, and it does require any official pro tempore, including the freelancers, to comply with any rule of court. That's all I want to say.
Thank you.
All right, and we have Anna Fatima Costa again.
And I would ask the same if you could sum up, if you could complete in a minute, since you've already spoken once.
Yes, thank you.
Thank you.
Carolyn, I'm aware of that law with regard to paralegals and legal secretaries and attorneys. So thank you for the clarity that court reporters need to do that as well. So again, I ended my last statement with a question, and I would appreciate, besides that law for official court reporters, is there anything in the codes with respect to freelance court reporters in the state of California, licensed in the state of California, to produce searchable PDF or PDF? Thank you.
I'm just going to say I'm not familiar with the codes relating specifically to freelance. And I have to say, I just assumed that freelancers were light years ahead of officials and would be doing all this stuff. I thought the officials would be the ones that would have been dragging their feet. And so I'm being educated as to the position of freelancers. I'm frankly really surprised that with the idea that an electronic transcript would not be searchable. Let alone add the bookmarks. I thought that would be, you know, we're using technology to our advantage by, we don't have to print. And I'm not aware of a code that requires a freelancer. Well, I already said that. I'm not aware of the code sections that govern freelance reporters. I could look into that, but I'm not aware at the moment. We use technology to our advantage. We don't have to print transcript. For myself and my colleagues, we look at it, we're thrilled we don't have to print transcripts anymore because we're able to, we've been fighting to try to file these things electronically. And we're thrilled now that we do. We can even do that with juvenile. Our Court of Appeal will even accept them for juvenile proceedings. And the idea that we would file one that was not searchable, I mean, it is required in the code, but that just seems like, why would we do that? We want to produce the best, most usable transcript possible. Now, I'm not a freelancer, so I don't understand the business side of it, and maybe that's another way to make money is then you charge if you can search it, but that's how I'm being educated. So is there any more public comment?
This is the moderator. We have Rosalie Jordan requesting to speak again. So I can.
And Rosalie, I would again ask you to limit your comment to 1 minute, please.
Okay, can you hear me?
Yes.
Yes.
All right, there's a huge issue in California with the sarcastic. So I just would hope that if we make a minimum
Rosalie,
requirement,
Rosalie, I apologize for interrupting, but do you have more than one device? Do you have a phone and a computer perhaps? Because we're getting a lot of echo. I'm having trouble
better?
hearing.
Yeah, so am I.
So, okay. I'm gonna go to another. Is that better?
Could you try again? Say again, please. If you're talking, I can't hear anything now.
All right, this is the moderator. Perhaps we can go to Charlotte. She says she has a 30-second comment. This is Charlotte Matthews.
Can you hear me?
Yes.
Yes.
Okay, it's only 30 seconds. I talk so fast. So the courts have a system of yes law that protects your product from being copied. We have the SoCal STIP in the freelance world, and that attorney is probably trying to get around this. Also, for the last 30 years, I have been able to OCR any document, and I mean any document. And I've worked for a number of law firms. I cannot imagine that attorney could not open up Word and scan that document and then be able to do a word search. He is disingenuous on this subject unless he is 80 years old. And he could have taken it down to Kinko's or FedEx or any of those and had that document OCR'd if that was really a problem. I just don't believe that this should change all of us to have to do this so that they can get around paying for the product. And I just think this is a bad move for all reporters to have to provide. It's fine in court. It's protecting their work product because they've got yes law, but this will put a real damper on the freelance world. Thanks.
All right, this is the moderator, and I just want to try one more time with the call-in user 11 to see if they can now unmute themselves. I don't want them to.
Thank you.
Yes. Okay, they're
Okay,
unmuted.
is it good now? Can you hear me okay?
Yes. Yes.
All right. My only concern would be that we would protect the language as far as providing a certified copy for review, read and sign, and the SoCal STIP and that whole big mess. Because if we are required to produce a searchable PDF, if we are, quote, locking a PDF, would that not be allowed any longer as far as protecting that original when it's being read and signed? And I don't know if you know what I'm talking about, but that would be my concern.
Thank you for the comment. I personally am not understanding, to be honest, about, I understand about the SoCal STIP. I understand, but I need to be educated. So in other words, I don't know how deep we want to get into this. And I don't know if it's appropriate. Well, go ahead.
Okay,
If you
I'm
could
just
explain
thinking,
just a little further, the
sure, and
process.
I don't want to open the whole can of worms, and maybe this is going to take more discussion, but the bottom line is at this moment, due to COVID and different things, witnesses cannot go physically and review an original transcript. So what reporters are doing, or to provide access to the transcripts for a read and sign, they are providing an electronic copy that is locked down, so it cannot be copied and sent out, and or they're having the witnesses read the transcript through Zoom, an electronic process. But I would worry that if this were becoming a part of the minimum standard, and an attorney can argue, a litigant can argue, that the reporter has to provide a searchable PDF for a read and sign as a certified copy, as opposed to right now it's only paper, and what the reporters have been doing is locking down the ability of parties to freely send out transcripts by getting a PDF. Does that make more sense?
It does. It does to me.
So I would be just very cautious with the language as to having to provide a searchable PDF to parties.
And you did not state your name at the beginning.
Oh, I'm sorry. This is Rosalie Cram.
Oh,
Rosalie.
hey, Rosalie. Okay, and may I ask, are you speaking for or against including searchable?
At this moment, I'm unless I see the language for how it reads, I would be speaking against it to ensure the fact that reporters are not required to provide a readable PDF to parties or searchable PDF to parties in the case of the read and sign, because that is a hot topic that I think we all need to be conscious of as far as the language. I
And
think it's a good idea to be able to provide the PDF, the searchable, but only in a certain circumstance.
so may I ask you, so the idea is by providing a locked electronic protects the freelancer from losing their copy cost. Is that correct?
That's a part of it, and but yeah, that's a big part of it, and just for the sanctity of the record of the original, quote unquote, because now there are not physical originals being produced, so as per the code, you're allowed to look at a certified copy, read it for reading sign, and send an errata sheet. And I'm just suggesting that the certified copy does not have to be something that would be available as a searchable PDF, or being reporters forced because of the new language to give that out as part of the product.
Okay. Thank you for your input. And good to hear from you. Are there any other members of the public that have comments?
Thank you, Madam Chair. There are not. So would you like me to close the question and answer panel?
Yes, please.
All right, it's closed.
And back to the board, I believe Miss O'Neill had her hand up first.
Okay. I don't know what order, but I have my hand up. As I've been thinking about this edition, at least, I work for a few different firms. I sent them an ASCII, and I know some of them use the yes law, and there's other features, but I'm done with it once I, send it off through a portal. And quite frankly, I don't think that those agencies, at least the ones I'm working with, very rarely will ever produce a paper. I mean, I think it's all electronic now, it seems to be. And that's all I have to say for now. I lost my train of thought.
Thanks, Miss O'Neill. Miss Hurt, your comments?
Thank you, Chair. I think for me, I would want to break this up into two different pieces. The first is your suggestion of adding additional pieces like the bookmark, etc. I at this time, because we are talking about the minimum transcript format standards, I would like to exclude that addition at this time. So then I'll bring it back to the second piece, or the original piece, which is that the text shall be searchable for the PDF. And I appreciated the public's comments and glad to hear from our former board member, Rosalie Crom. It's always a pleasure to hear from her, and of course, all the public comments. And to respect the sanctity of the original, but at the same time, I guess, with the evolution of court reporting and stenography, keeping up with the minimum basics. And so I'm having, I guess, as a public member, a little bit of a struggle on making sure that the language we create is not doing more harm than good in this process. I would say that not being able to pass over an electronic version seems not keeping up with times. However, I would like to ask a question, and maybe Ms. Finner or our legislative attorney or whomever could answer this question. when we allow a searchable PDF, and that means the language that's suggested in line 12, are we harming the sanctity of the original? Can someone speak to that, which was kind of put out in public comments? I want to, again, do bare minimum. And I think one should be able to have an electronic version, not just a paper version. But I would like to understand that a little bit more before I put a stamp of yes.
Hi there, this is Danny Rogers, Regulations Counsel. I'm not sure I would know the answer to that. It seems more like an electronic or technical question as to whether it would do damage to the underlying transcript itself. I would refer that out to someone who might have a little more knowledge in that area.
Madam Chair, if I could address that, I think.
Yes,
So,
please.
irregardless of someone taking the copy and changing it, your original is still intact, and the other certified copies that are out there are still intact. And so if one person makes the decision to change, say they're in custody of the original even, if they take it upon themselves to make that change, you have other certified copies that are out there. And if it's a change that is substantial, that's going to matter to anybody's lawsuit, then the opposing counsel is going to point that out to the judge. And then the person that changed it, I would imagine, would be disbarred. So I think that, there's kind of a built-in safety mechanism there for changes. And at the end of the day, if there is any doubt, then of course you have the court reporter who created it.
Okay, so there's a safety net of sorts in the original being kept. Okay, I actually, after hearing everyone's comments, I don't have a problem with moving forward with just line item number 12. The text shall be in a full text searchable PDF or other searchable format. I do hear the care we need to take in this language. I haven't heard anybody expert-wise point out that this would upset the sanctity of the original, or and I haven't heard, or proof hasn't been provided that that this is just a software update, that it's not more than that. In other words, it wouldn't cause people to need new machine technology, etc. So I think I'm going to move forward with that. I look forward to hearing other board members' conclusions, but I think at minimum, line item, what is that? A12 is in keeping with our ability for minimum transcript format standards.
Miss O'Neill, your hand is still raised.
Oh. I keep going back and forth on whether or not I want to say something. Just a moment. Okay, what I, in the back of my mind as I'm thinking about all of this, is going back to the minimum transcript format standards. If we kept something like number 12, if we kept something in the minimum standards along the line, I would, just because, people create new software going along, and I would not restrict it to PDF portable document format. I would just say electronic format. The text shall be in full text searchable electronic format. Okay, or other searchable format.
I think that's a thoughtful comment, Board Member O'Neill.
Yeah.
Could we get,
I-
sorry.
No, I see before, I'd like to call on Ms. Tugade.
Thank you.
You're welcome.
And actually, I appreciate that question. I was wondering, kind of bouncing off of both Ms. Hurt and Ms. O'Neill's comments, maybe rather than PDF, does it need to be specified that it's I guess in a format where that's not easily editable? I mean, I know with PDFs that's changing how easy it is to edit those documents, but does there need to be some additional language to specify that this is, in addition to whatever watermarks or other kind of electronic signatures are there? Are there other safeguards that need to be there?
Good question. Well, I interrupted you, Ms. Hurt, when you were answering or conferring with, discussing the issue about electronic transcript versus PDF with Ms. O'Neill. But I saw Ms. Tugade's hand up and then and down and when I saw it back up, I wanted to make sure I called on her. So.
No, it's no problem. I've been talking a lot during this board meeting, so it's great to take a pause. I just wanted to echo and thank Board Member O'Neill for, just basically pointing out that it could be an electronic version. PDF is standing for portable document format, and as Board Member Tugade said, it's becoming easier to edit that, but I want everybody to keep in mind what Ms. Finner said, which is you make edits or changes and it's actionable against you for disrupting or editing the transcript. So I don't think we need to worry about the language here, but I'm not opposed to adding, if folks feel better, taking PDF off and just saying electronic. That's all. I've said already enough on this.
Okay.
So Ms. O'Neill?
Sorry, I had another comment. I was thinking, it just popped into my head. The attorneys out there are becoming accustomed to getting their transcripts electronic form. However, I have had several occasions where the taking attorney wants a paper copy. And so I just have to put in, the worksheet that's what's going on. And where I'm going with this is that I would hate for number 12, for the language there, to me, it sounds like shall. It has to be in PDF or other searchable format, which a paper transcript isn't, yet that's what the client wants. So
In other words, this should be if an electronic transcript, I'm sorry?
If requested?
If produced electronically, if transcript is electronic, it should be fully searchable, or?
All we have to do is
understand.
add if requested.
Okay. Oh, there you go. Much easier. Thank you. So what I heard, correct me if I'm wrong, is to change the language to text shall be fully text searchable in electronic format, comma, if requested. If requested in electronic format, comma, text should be full text searchable.
I would put if requested, comma, text shall be in full text searchable PDF format or other searchable format, because then that takes care of I'm trying to think of how to say in a nice way, an old attorney who wants paper.
Well, I think that if requested takes care of that.
That's what I'm saying. Just add at the
If
beginning.
requested, comma, text
Mhm.
shall be in full
Yeah.
text searchable electronic format. Because we're trying to get rid of the PDF,
Yeah.
correct? Is that correct?
Yeah. Because, I mean, yeah, PDF is used a lot now, but in 2 years, something entirely new may come along that does the same thing. And it's in electronic format, but it's not called, the brand name PDF.
Can I make a suggestion? I mean, I understand if require or if requested, but by that statement alone, it means that everybody needs to be prepared to be able to do that. So that added language, I don't think improves it. And when I mean the added language, I mean the if requested. It doesn't say text is required. It's like text shall be in full PDF. So I
would have a concern as well if I could be heard briefly. The concern I would have, and I would want to take a little time apart from the meeting to look into it, is the California Rural Court imposes the requirement that it be text searchable in certain circumstances and civil appeals in particular. So I would be reticent to insert words that make it permissive in the minimum in the regulation, which might conflict with a requirement in the rural court. And so what I would want time to do is to work on it and carve out the instances where it's required and basically draft language that would not make it permissive where it's required, but where it is permissive, have it be permissive, if that makes sense. I simply don't want to write language that conflicts with a mandatory rule somewhere else. That's my concern there. Thank you.
Thank you. And you, just to be clear, you understand the concern is that we're not tying someone's hands. They have to do it electronically. They could do either electronic or paper. But if it's electronic, then this would apply.
I understand.
Thank you. I think just.
Thank you for explaining.
Sure. Ms. Venner?
If we're not going to discuss it any farther, then I'll work with Danny in between meetings.
Okay.
Do we need a motion? No motion. Okay. Thank you. So what time? Okay. So we're going to move to agenda item 8, which is the licensure of voice writers. Ms. Fenner, will you start us off, please?
Thank you, Chair Sunkeys. For the board members that have been around for a bit, you will recall that back in 2018, the National Verbatim Reporters Association approached us and asked that voice writers be licensed to practice in California. We had a demonstration of real-time reporting skills at our July 2018 meeting and subsequently voted to move forward with licensing voice writers. We, at the time, believed that existing statutes allowed for us to move forward, but the legislature disagreed. We were following up with staff from Senate Business Professions and Economic Development Committee on an offer to gather stakeholders together and see if there was a path that we could agree on to licensing voice writers. And then along came COVID. And all such plans were put on hold while we kind of each individually reordered our various universes. But now that business has returned somewhat to normal, staff thought it was timely to resume those negotiations. But in light of the fact that it's been such a gap from being on the board's agenda, so to speak, we wanted to place it before you for discussion and confirmation that that's still an initiative that you would like staff to be pursuing. If it's the pleasure of the board to move forward, staff is looking for a little guidance when we meet with the stakeholders. We've offered up a couple of sample questions on page 114 of the board meeting materials, just so that I'm well informed when I'm meeting with a larger group on if the board has certain things that they definitely want, definitely don't want, or really are open to anything that stakeholders bring to the table. And with that, I'm happy to answer any questions if that brief history was too condensed.
You're on mute, Chair.
Sorry. Miss O'Neill, your hand is up. Did you have,
Oh.
was that for this topic?
No. I
Okay.
took it down. Oh, mine shows it was lower hand. Okay. No, I
Okay.
don't have anything yet to talk.
So before we go to public comment on this, but before we take this up, I'd like to ask Margaret Ortiz, the program coordinator for court reporting and related technologies at West Valley College, to share information on their voice writing program.
This is the moderator. I just promoted Maggie Ortiz to a panelist, so she should be able to unmute herself now.
Okay, I think I'm unmuted now. Can everyone hear me?
Yes.
Yes. Okay, thank you very much for this opportunity to speak to the board. We started a voice writing course this spring because we were looking at the following points. I'll try to remain brief. I'd like to give Linda Lawson, who is one of my co-instructors, a chance to make a few comments as well, if that's okay. I recently did some research last week and found 32 California County Superior Courts are currently advertising for court reporter positions, and some are advertising for multiple positions, and almost all of the positions are for full-time employment. I regularly receive emails from deposition firms looking for reporters to fulfill jobs they have. Clearly a shortage. Not enough reporters are qualifying through school programs and or simply passing the CSR skills examination to fill the shortage, to the best of our observation. Voice writing, along with machine stenography, is currently being used successfully in 36 other states in the US, as well as for many years in the US military and in federal courts. The states that have voice writers also have steno writers, and they still have court reporter shortages. So we don't believe that voice writing will replace stenographic machine writing, but will be an alternative way to produce a quality transcript. And I realize that the board's mission is to protect the consumer, and the end product is exactly the same, as long as the person is well trained and qualified in either voice writing or machine writing. I'd just like to share with you very quickly some of our internal observations in our program. In just one semester of taking our voice writing course, students of ours who were not progressing in machine writing usually stuck between 80 words per minute and 160 words per minute, were able to read back accurately at speeds from 180 to 220 words per minute and produce speed test transcripts with higher accuracy than most of our machine writing students, 98% and above. One of our students who couldn't pass the required tests at 160 words per minute, after being in our program for several years, passed a 5-minute, 225 word per minute 2-voice test with only 7 errors. 4 of them were punctuation after just 11 weeks of voice writing training. Several of our voice writing students have passed 1 or more qualifier skills examinations 1 student within a year of voice writing only, no steno background, and 2 other students who learned stenographic machine theory first passed within 1 semester. The voice writing technology does use Dragon speech recognition software in conjunction with CAT software. We are teaching using Eclipse Vox. It also works with Case Catalyst, and it is facilitating the production of more accurate transcripts by students in far less time than most machine writing students. So I just wanted to share that with you, and maybe ask if Linda Lawson could share a few comments as well. Is that all right?
That would be great. Yes.
Okay, thank you very much. And Linda Lawson, if she gets permission. And then either Linda or I would like to read just a few quick student comments from our students at the end, if that's all right.
Yes.
Yeah. Thank you.
Am I unmuted now?
Yes, we can hear you.
Oh, you can hear me. Great. Thanks so much. I'll try to be brief also. I have sent a 2-page letter to the board, but I will just read a few comments from that board, a few paragraphs. Here we go. I have been teaching court reporting for over 40 years. Every semester, I have seen a new group of optimistic, hopeful students, many with good educational backgrounds, come to our program, hopeful of becoming court reporters, the interesting, exciting career that many of you have had. It is more likely that 90% of them will not make it. They'll drop out of the program before reaching that goal. Over 10 years ago, I began my investigation of voice writing because I had heard about it. At that time, the technology wasn't there to produce good real-time translation, but now it is. With the advances in computer processing power and speech recognition technology, advances in real-time voice writing have reached a level comparable to stenographic writing. I think it was in 2018 that the board decided to approve voice writers. The minute I read that, I ran out and got a brand new dedicated computer and the associated equipment. I've taken at least 3 courses myself to learn more about voice writing. So students that are approximately 3/4 of the way through theory are learning to write words like reluctance or dangerously, multisyllable words. Those students are writing at about 30 to 40 words a minute at that time. They have been in theory class for several months, and they're struggling to learn to write these multisyllable words. They will over time, but at the same time, a voice writing student will be able to write these words on day 1 by simply speaking the word. Voice writers are not to be confused with digital reporters, which are really recorders. Digital reporters make an audio recording of the proceedings. The voice writer is the licensed person responsible for the legal record. They are present to read back when requested, to interrupt when more than one person speaks at the same time, to ask for repetition of a question or answer when necessary, to provide immediate real-time translation for the benefit of the judge and attorneys, and to produce a transcript of the proceedings, often on the same day. Voice writing students, classmates, many of whom have been in the program for more than 3 years, have not passed a single qualifier. Maggie gave you the information on the progress that the voice writing students have made in speed building courses, so I don't think I'll repeat that part of this. Sometimes I wonder how long the colleges are going to keep supporting court reporting programs when we are able to send maybe 1 or 2 candidates to the CSR exam every semester or every year. And the numbers with our college are not much different than with other California court reporting programs. So with the current documented shortage of stenographic court reporters, the limited number of stenographic students qualifying for and passing the state exams, the closure of stenographic court reporting school programs, and the infusion of digital recording in the legal arena, the result will be that this vital responsibility of providing the accurate legal record for the California consumer will be taken over by digital recording, the least competent method. Thank you.
Thank you, Ms. Lawson. And did you say that you had further comments, Ms. Ortiz? To wrap
Yes.
up?
Yes, thank you so much. And thank you for giving me the time to do this. And I just did want to make one additional comment that Linda did start teaching our very first voice writing course this last spring. We've been telling students that they are not able to use it in California to become court reporters. So we are focusing on captioning. But a lot of those students have already taken the academics needed for court reporting because they were already steno students. So from one of our students, Elena Murphy, I'll just read a few of her comments. She said, when I started stenography about 2 years ago, I was completely committed to the long haul. I knew it would probably take me way more than 2 years to get to speed, especially because of how late in life I was starting. When my school offered voice writing theory, I was interested, not because I was giving up on steno, but because it seemed so much easier and more intuitive, and it is. I was writing steno at just about 90 words per minute when I took up voice, and in between 4 and 5 months, I passed my 200/225 question and answer exam, lit and jury charge, and my 184 voice using voice writing. My transcripts are much closer to 99% error-free on a regular basis as well, which I was not doing nearly as well at in steno. And as for voice writers taking steno jobs, I really don't see it. There are so many jobs out there now. And I just wanted to share her comments. And then just one other student, Natalie Dorico Lindsay is her name. I am now using voice writing in my speed class. I am turning in my tests. I am much more confident with this style of writing, and I actually enjoy doing the work, which will allow me to perform much better and more often. I am very excited about this opportunity. I feel voice writing is a career to enjoy, along with the feeling of doing a much needed service for others. She's looking to doing captioning, but I thought her comments were very good. So we just wanted to say thank you to the board. It's an amazing technology. It does take work. It's not something everyone can do. And it does take work and practice like stenography, but we do feel it's much more attainable to provide the same product to more students. Thank you very much.
Thank you. Thank you, ladies, both of you.
Thank you.
Before we go into public comment on this topic, on this agenda item, I would like to suggest we take a comfort break. We've been going at about an hour and a half since we came back from after lunch. So 15 minutes.
Okay.
Everyone, does that sound good? Thank you. There we go. Okay, as a friendly reminder, we are recording this and it is also being broadcast. And we are back on agenda item number 8, licensure of voice writers. And we are to the point where we're going to open it up and ask for public comment on the issue.
Thank you, Madam Chair. I have opened up the Q&A panel. If any member of the public would like to make a comment, please type "I would like to make a comment" and send it to all panelists using the field in the lower right-hand corner of your screen, or you may raise your hand. Again, these are comments for agenda item 8. And I see that we have Carolyn Dasher that would like to make a comment. So Carolyn, Let me unmute you. And you're unmuted.
Thank you. Okay, with 6,000 licensed CSRs in California, I do not believe we currently have a shortage. There are over 2,000 licensed CSRs in Los Angeles County, and there's only 450 spots for official court reporters. And we also have court reporters working in LA County who live in different counties. Now, in 2012, courts up and down the state laid off court reporters and created this two-tier justice system where wealthy litigants hire freelance reporters and indigent people have no record. And now we have, and we see up and down the state, many freelancers are making astronomical amounts of money providing their services to multiple civil cases. And there is no impetus for them to become official reporters. And official reporters are leaving their jobs to become freelancers to cash in on this. And because there hasn't been a transcript rate in 32 years, and the courts are taking away vacation time and not offering incentives to hire court reporters, that should be a clue to all of us that the Judicial Council is trying to do away with official court reporters altogether. Now, the courts have shifted these costs clearly to the litigants and not taking action to recruit court reporters. That being said, on behalf of the Los Angeles County Court Reporters Association, we do not object to the board looking into voice writing. We believe they must have the same school curriculum as a stenographic reporter laid out in the regulations by the Court Reporters Board. They must have the same testing requirements, the same licensure, perhaps with a V, as in CRV distinction, or certified, however. They must be on the same professional level. They must have the same salary range. So we keep all forms of the record on a professional level and everyone working at the same level. Thank you.
Thank you, Ms. Dasher.
All right, and our next request for comment is from Anna Fatima Costa. So let me unmute you. You're unmuted.
Thank you. I appreciate the comments by Margaret Ortiz and Linda Lawson, and as well as by Carolyn Dasher. I have coached 11 voice writing students in the last 5 years. And I was present at the July 2018 meeting when the board voted to allow voice writers to sit for the March 2019 exam. And I invited one of the voice writers to be my very first apprentice at a series of mock depositions in March. So it's shocking to hear that there was no legislative authority to allow voice writers to sit for the exam. Just really confused as to how the board could vote for that without having the legislative approval. That being said, with regard to what they have the same struggle. They are in tears, not able to pass a speed or reach a speed. Not only do they have the same struggles as machine writers, they're both steno, but they also have to learn how to breathe while they're repeating everything. There is no correlation whatsoever between a digital recorder and a voice writer. With regard to the two questions that the board is asking, I'm curious why it even comes up that you would allow those who hold certification by the NVRA, but you're not allowing reciprocity with NCRA or Texas. Shouldn't NVRA also pass the OPUS parameters or thresholds before even considering that question. I agree wholeheartedly with what Carolyn Dasher said. Everybody should be required to pass the California skills on all the exams and the written portions as if they were machine writers.
30 seconds.
Thank you. And I don't know if a separate license category is needed. I think there's a great deal of misunderstanding in the court reporting community about voice writers. And if the board wants to consider it, they need to take time to educate. And one correction, it is not true that most machine writers get through school in 2 to 4 years. It's my experience, it's 4 years and above.
All right, our next request for comment is from Charlotte Mattias. So Charlotte, I'll let you know when you've been unmuted. Charlotte, you're unmuted.
Can you hear me?
Yes.
Okay, great. Hi, this is Charlotte Mathias, CSR 9792 RPR, and I would be a really fast voice writer, but I do hope that they have to take our test. They have a similar test to the RPR, same type of 3-part test, same speed. I think our test is really important, so I have no problem with a voice writer. You can write, if you can write with a pen with your toes, play it on a piano. For me, I don't care how it's done, but it needs to be R4 voice test. That's what I really hope that this board does. I know the last time this came through, you were talking about allowing CSRs who've already passed the test stenograpically that we could be voice writers. I don't know if that's something you are still considering, or if you're going to do a separate certification. That would be something that would be interesting. At the time that you were discussing passing this a number of years ago, I spoke to many attorneys, and I think before you vote on actually passing this, you need to maybe do a town hall meeting with lawyers. A number of lawyers I know who have used voice writers, they were JAG officers, would be totally against this. So even though I'm okay with it, the attorneys might not be happy with it. And I don't know if you've reached out to the Bar Association and done some sort of a town hall with them to let them give their input on voice writers. Again, the JAG officers I worked with said they would definitely change their notices to make sure they had stenography. They don't want voice writers. So I think that needs to be something that needs to be looked at. Also, can voice writers currently work in California since they're not really stenographers? Even under your purview right now, I'd love to know that if Yvonne can answer that question. And then I think that's pretty much all I had to say. But yeah, if I can find out if voice writers are not really stenographers, because under Merriam-Webster it doesn't fall in that. Can they even practice in California currently since they're not really technically under the board's jurisdiction? I'd love to know that answer. Thank you.
All right, and it looks like our last request is from Carolyn Dasher.
No, I'm done. Thank you.
Okay, all right. Then it looks like we are done with comments. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
Ms. Fenner, you had your hand up?
If you'd like, I can respond to Matthias's last question.
Yes, please.
So they are not licensed by the state of California. They cannot work in court as a voice writer. However, if attorneys wanted to stipulate that that's how they would like their record made, then they would be able to practice. I can't say whether that transcript, because it was not prepared by a CSR, would be accepted in court. That would be up to the judge. So that's the status of voice writing in California.
Thank you. Ms. Ortiz, you had your hand raised?
Yes, can you hear me?
Yes.
Okay, thank you for letting me make an additional comment or two. I just wanted to answer a couple of the questions that were asked. I just wanted to make it very clear that at West Valley College, we are not trying to send voice writers out in California, we realized that you need to be a licensed CSR, and that is on the steno machine. I also wanted to mention that we teach all of the same academic courses, though. And so if voice writing is accepted in California for licensure, then our students would be qualified and take every single course that our machine students take. The only difference would be that they would be producing transcripts using voice writing rather than stenography technology. Thank you.
Thank you. Do we have any further discussion from the board? Members of the board?
I do.
Okay.
Yeah.
Miss O'Neill?
I going to take the same position I took before the COVID-19 came along. That you know that we should move forward toward licensing of voice writers. I do think they should take the California skills test. And then number 2 about differentiation between whatever you call it, initials. I tend to think that they're going to be doing the same job that we're doing. We're just all CSRs. But I'm open to discussion. Thank you.
Thank you. Miss Hurt, you had your hand raised?
Chair. I just wanted to thank the guest speakers on this item, as well as the public commenters. We all know voice writing has been around for a really long time, and this is not a new method of taking the record. They've been done in important spaces. That's in our staff report. And I too remember back in July 2018 when they gave a demonstration in real time and with great accuracy. So I think further discussion with the various stakeholders is indeed warranted. I think everyone, of course, wanted, even at that time, and I'm sure today as well, ensure that they're up to the standards and competency of those who are required or who are using stenographic machine to make the record. So to that first question, yes, they should be required to pass the California skills test, or at least rather be able to demonstrate the same competency in a California skills test. I too had wrote to the side here the conversation around certification of NVRA and whether an occupational analysis could be done to understand their schooling. Maybe Ms. Finner, do you have any background that you could present to the board as well as the public before I wrap my comments up?
I can address the occupational analysis aspect of it. In anticipation of that question, I did reach out to NVRA. I do know that they have conducted an occupational analysis. I thought it would be premature for me on my own to ask OPES to do the validation and the analysis on it. But if that is the board's pleasure, then I can follow up with OPES specifically on the NVRA testing.
Thank you, Ms. Finner. I'm glad to hear they have conducted an occupational analysis. And I think in the stage of talking to stakeholders.
So if voice writers can meet our testing standards, if they can produce transcripts, if they can produce real-time reporting, which for the industry of court reporters, that is the gold standard, real-time reporting. If they can do those things, why would we not license them? It's the same job, just a different method. And I agree with what was said earlier by a member of the public that we want a professional, licensed person protecting the record, and maintaining the salaries and maintaining the position and the professionalism. That's what we're looking for. But as the board, our job is to ensure that we've got an adequate number of licensees to meet the needs of the consumers of reporting services. So those are my comments. I see Ms. Hurt's hand up.
Thank you. I'm not quite sure why you may have singled out myself on the comments related to the differentiation. Should it be a separate license category? But I just want to make clear to the public that I don't have an opinion about that just yet. And in fact, I would like the stakeholders to discuss the pros and cons to that aspect. So I wasn't quite sure, by saying Board Member Hurd, if you thought that I had said that or not. I absolutely have not made a decision on that. And I want to ensure that we weigh both and figure out what's what. That's all. Thank you.
I did not mean to imply that you had taken a position on the issue. In fact, what I heard you say is you'd want more further information on the issue before you took a position. So I was just offering that information for you to consider. And I do see that Ms. Lawson also has your hand raised. Was that current? Did you
Yes,
have a comment?
If I could, just two quick comments. And one is in reply to the comment about attorneys perhaps not accepting voice writers. I think people more and more, the population, the attorneys, and everyone is really becoming much more comfortable with speech recognition. We can talk to our phones, we talk to our cars, and the translation's pretty good. It's not there with punctuation, it's not there with speaker designations, as the court reporter will do, but I do think attorneys will accept it if they see a demonstration of how it works. And then the second thing I would say is that with Dragon or any speech recognition engine, seems to like the big words. So when I see a demonstration of a steno writer and a voice writer reading something perhaps with a little bit of dense technology or terminology, the voice writing really does pick up the big words much better than steno unless the steno writer is very, very good. Okay, that's all. Just wanted to make those 2 points.
Thank you very much. So Ms. Hurt, your hand is still up. Does that mean you had further comment? Okay. All right, great. So is there a motion is there a motion that the board pursue legislative changes to explicitly allow voice writers to be licensed to practice in California?
I would make that motion.
Okay. Ms. O'Neill moved. Do we have a second?
I'll second.
Thank you. And Ms. Tugati, second. Is there anyone from the public who wishes to comment on the motion?
Thank you, Madam Chair. I've opened up the Q&A panel. If anyone would like to make a comment on this agenda item, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists. You may also raise your hand. We'll give you a moment. All right, we have Anna Fatima Costa who'd like to make a comment. So Anna, let me unmute you. You're unmuted.
Thank you. I am sorry, I did not hear the motion. Could you please repeat it?
The motion is that the board pursue legislative changes to explicitly allow voice writers to be licensed to practice in California.
Thank you very much.
Any other public comment?
No, there are no further requests for public comment. Would you like me to close the Q&A panel?
Yes, please.
Okay, it's closed.
Ms. Bruning, would you please call the roll to vote on this item?
Yes, thank you, Ms. Hurt. I didn't hear anything. Can you repeat that?
Aye.
Thank you. Ms. O'Neill?
Aye.
Thank you, Ms. Dugade?
Aye.
Thank you, Ms. Sunkis?
Aye.
Motion carries.
Thank you. I would direct staff to reach out to the Business Professions and Economic Development Committee to further discuss this issue. And that takes us to agenda item 9, strategic plan. Ms. Spinner, is there any truth to the rumor that the CRB now has a Facebook and Twitter account?
Yes, indeed, Madam Chair. Since the meeting materials went out for the board book, I'm happy to announce that both our Facebook and Twitter accounts have gone live. So yes, in 2021, the Court Reporters Board can boast a social media presence. So that segues smoothly into our action plan, which is found on page 117 of the meeting materials. And you can see that a lot of the spaces that are left blank, I think that having the ability to reach people on social media will help us tick off a bunch of those boxes. Because a lot of the remaining items on our strategic plan involve outreach. And yes, there still is mail and there is email, but I do believe that a lot of people are getting their information on various forms of social media, and I think this will help us reach more people.
Thank you.
And as always, I encourage the board members to let us know if they want us to reprioritize anything that's on that action plan. As you know, we've been running kind of lean with staff. Hopefully we're finding our feet. We do have a wonderful new halftime OT that is helping us free up a lot of staff time by jumping in and taking where staff had jumped in to take those responsibilities. They're being able to be handled by our new personnel person right now. And I think it's going to be really exciting to have what we would call a full staff back on.
Very nice. Thank you very much. Are there any comments from the public?
Thank you, Madam Chair. I will open up the Q&A panel. And if a member of the public would like to make a comment, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and send it to all panelists. Or you may also raise your hand. We'll give you a moment. Madam Chair, I'm seeing no requests for comment at this time. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
Thank you. And are there any comments from the board? Ms. Hurt?
Thank you, Chair. And thank you, Ms. Spinner, for getting the Facebook and our social media presence moving forward finally. Hallelujah. And what I start off that way because when I look at our action items, there are 3 that have a target date of December 2020, or actually 2 of them, and 1 January 2021. And obviously COVID has changed, as you said, the priorities on things. So I think everything that we're doing right now is appropriate. But I was just curious, kind of your thoughts around maybe being able to use the Facebook to support school recruitment efforts to preserve the integrity and continuity of the workforce. Also inform licensees regarding the role of the board's enforcement to dispel common misconceptions. It seems like maybe these are some topics that can be on those social media pages and could be started sooner than later, even with just a statement. I know we've talked about dispelling misconceptions through our best practices, but I know that takes a lot of effort to get people's schedules and things together. So maybe just using social media to make statements and remind folks could be a way to do that. And so I'll stop there and see if that's something we can do as a board.
And I'm happy to let you know that the recruitment was one of the very first things on there. We have information on, as one of the initial posts with the student brochure, which contains information on the industry, on the profession itself, as well as how to get in touch with the board, which would have access to the schools with links to the schools. So that was definitely one of our high priorities and is going to be one of the initial postings. We don't have content particular to the enforcement part of it developed right now, but clearly this is my list. This is my to-do list, so it will be coming.
Okay, thank you. I know we are lean staff, so I appreciate all the work that's being done, and glad to hear you will be a complete staff soon. So thank you.
Any other comments from the board? Okay. Well, thank you. I'm very excited. I've been saying to Miss Fenner, what about Facebook? What about, well, and I'm not on Twitter. Now this will get me on Twitter. You know, I'm just old school Facebook. So thank you very much for making this happen. Would perhaps, of course, this kind of goes with the support the schools recruitment, maybe, notice of A to Z programs starting, available for prospective court reporting students? Would that be something to I put that out there if it's something that's appropriate to consider for our social media?
I think it would be. So if associations or groups that are putting those programs together would like us to also publicize it, it would be totally appropriate. And I also want to do a big shout out to the Office of Public Affairs from DCA, because obviously they were the ones that were the hands-on folks that made this happen, and I appreciate all of their hard work.
Thank you. Thank you. Thank you to them as well. So are we ready to move on to agenda item 10?
Yes.
Okay. We are holding our first meeting of the new fiscal year, which requires us to elect officers for the coming year. Do we have any nominations for the position of chair?
Yes. I would like to nominate Robinson Keys to continue as chair for next year.
Thank you. We have a motion. Do we have a second?
Second.
Thank you. Was that Denise? Or was that Ms. Hurt?
That was Davina.
Thank you, Ms. Hurt. Do we have any comments from the public before the board votes?
Thank you, Madam Chair. I will open up the Q&A. All right, the question and answer panel is now available. If any member of the public would like to comment on this agenda item, please type "I would like to make a comment" using the field in the lower right-hand corner of the screen and send it to all panelists. Or you may raise your hand. We'll give you a moment. This is the moderator, and Madam Chair, I see no requests for comments at this time. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
So, no, we have a motion and a second to nominate Robinson, myself, as chair of the board for this fiscal year. And Ms. Bruning, will you call for the vote, please?
Thank you. Ms. Hurt,
Aye.
Ms. O'Neill,
Aye.
Ms. Dugade,
Aye.
Ms. Sunkeys.
Aye.
We will take your affirmative vote on that, Ms. Sunkeys, to assume you are accepting the position as nominated, and then motion carries. Thank you.
Thank you very much. Ms. Hurt, I see your hand raised. Did I jump the gun? Did you have a comment before?
No, I'm sorry. I sit on other boards and I'm used to them putting my hand down, and so I forget
Got it.
sometimes.
No
Sorry.
worries. No worries.
Sorry.
Thank you. Now we need a nomination for a vice chair. We need a motion for a vice chair.
Yeah, I would like to make a motion to nominate Davina Hurt as vice chair for the next fiscal year, or the fiscal year we're in.
And do we have a second?
I'd like to second.
Thank you. Do we have any comments from the public before what the board votes?
Thank you, Madam Chair. I will open up Q&A. If any member of the public would like to make a comment, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may raise your hand. We'll give you a moment. This is the moderator. I see no requests for comment. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
So we have a motion and a second for Ms. Hurt to be vice chair for the next fiscal year. Ms. Bruning, would you please take the vote?
Thank you, Ms. Hurt. Do you accept the nomination? And may I have your vote?
Aye.
Thank you. Ms. O'Neill?
Aye.
Thank you, Mr. Gade.
Aye.
Ms. Sunkeys?
Aye.
Thank you. Motion carries.
Thank you. And thank you, Ms. Hurt. So agenda item number 11 is moving on to future meeting dates. We have tentative dates of November 2021 and March of 2022. Per our usual custom, staff will poll board members offline about their availability for dates in November. Are there any public comments on the topic?
Thank you, Madam Chair. I will open up the Q&A panel. And if any member of the public would like to make a comment on this agenda item, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may simply raise your hand. We will give you a moment. This is the moderator. I see no requests for comment at this time. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
Any members of the board that would like to comment on future meeting dates? Okay, then we will move on to agenda item 12. The board has no matters to hear in closed session. But before I call for adjournment, I would ask that we take a moment of silence in memoriam of Toni Pallone, a woman who has contributed so much to the court reporting profession. With that, I will call for a motion to adjourn the meeting.
So moved.
Ms. O'Neill moved. Do I have a second?
I'll second.
No need for a second or to vote.
Okay, then I will, meeting adjourned. I want to thank everyone for your participation today and all the comments from the public and our guests that had comments and presentations today. Thank you so much. And thank you, Ms. Fenner and Ms. Bruning very much. And Ms. Moderator, you too. Thank you.
And thank you, Chair, for leading a good meeting.
Thanks.
Thank you.
Have a great weekend, everyone.
All right,
Thanks.
bye.
You too.